Thank you all for joining us today. Unfortunately, Thomas Emmett is unable to attend live due to unforeseen circumstances. However, he has pre-recorded the webinar for us. Please do still make use of the Q&A facility, as Thomas will respond to your individual questions after the event.
Hello and welcome to our Wednesday webinar. Burkitt Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. My name is Thomas Emmett, I'm the Head of Education at Burkitt Long, and this week we're looking at the law on pupil exclusions. In this webinar, I will start with a brief introduction before moving on to the sources of law and guidance, both statutory and non-statutory, relating to exclusions. I will talk about the power to exclude and the types of exclusions that are lawful. I will also discuss the duty to arrange education for excluded pupils and the information duties on governors and head teachers. I will then move on to send specific guidance and then provide details to you on how you can contact me to ask me any questions relating to this webinar. As I'm sure you're all aware, the purpose of school discipline is to promote good pupil behaviour. Discipline can help prepare pupils for adulthood and employment. However, it is important when exercising any form of disciplinary action that it is exercised in a way that is lawful. Fixed period and permanent exclusions are sanctions for misconduct at the top end of disciplinary sanctions available to a head teacher. Before I conclude the introduction, it is important to highlight the link between exclusion and special educational needs. Statistics released by the Department for Education in July 2019 showed that pupils with special educational needs support had the highest permanent exclusion rate and were over 5 times more likely to receive a permanent exclusion than pupils with no special educational needs. Pupils with identified special educational needs accounted for almost half of all permanent exclusions and fixed period exclusions, despite making up only 15% of the school population. Pupils with an education, health and care plan had the highest fixed period exclusion rate. Both pupils with EHCPs and on special educational needs support were almost 5 times more likely to receive a fixed period exclusion than pupils with no special educational needs. I set out on this slide and the following slide the Acts of Parliament, the conventions, the regulations and the guidance, both statutory and non-statutory, that relate to pupil exclusions. I will make reference to some of the Acts of Parliament, regulations, conventions and guidance throughout this webinar. The Education Act 2002, as amended by Section 4 of the Education Act 2011, contains the power to exclude. In Section 51A, it states, the head teacher of a maintained school in England may exclude a pupil from the school for a fixed period or permanently. The section also states that a teacher in charge of a pupil referral unit in England may exclude a pupil from the unit for a fixed period or permanently. What can be taken from that section, therefore, is that there are only 2 types of exclusions which are lawful, that is permanent and fixed period exclusion, and that only the head teacher of a school or the teacher in charge of a pupil referral unit can exclude a pupil. This is repeated in this webinar, but is important to point out from the outset, and something that can often catch head teachers out, is that informal or unofficial exclusions, such as sending pupils home to cool off, are all unlawful regardless of whether they occur with the agreement of parents or carers. Any exclusion of a pupil, even for a short period of time, must be formally recorded. Statutory guidance published by the Department for Education states that a decision to permanently exclude a pupil should only be taken in response to serious or persistent breaches of the school's behaviour policy, and where allowing the pupil to remain in school would seriously harm the educational welfare of the pupil or others in school. What can be taken from the statutory guidance is that pupils can only be excluded permanently for disciplinary reasons. A child can be sent home on medical grounds after consultation with their parents and a medical professional as appropriate. This is an authorised absence and not an exclusion. When a head teacher is notified that an incident has occurred which is potentially serious enough to merit exclusion, they must ensure that a full investigation is undertaken. It is essential that their decision is based upon a clear understanding of what has happened and what aggravating and mitigating factors might have been at play. This will involve gathering as much evidence as is possible about the offence itself, as well as all of the relevant information available about the pupil. In some cases, there will be little dispute as to the underlying facts. In other cases, the pupil may completely deny any wrongdoing, or they may offer an alternative or competing account which, if accepted, would mean that the conduct was less serious or more understandable than it appeared. In these circumstances, a head teacher must conduct an investigation, gather evidence, and come to a conclusion about what actually happened. The process of the investigation and all the findings of the investigation must be recorded in writing. When establishing the facts in relation to the alleged misconduct of a pupil, a head teacher must apply the civil standard of proof, i.e. on the balance of probabilities, is it more likely than not that a fact is true, rather than the criminal standard which you might all be more familiar with, which is beyond a reasonable doubt. In some cases, a pupil's misconduct may lead to police involvement and the institution of parallel criminal proceedings. The pupil may feel that the head teacher should await the outcome of such proceedings before deciding whether or not to exclude. There is no obligation upon the head teacher to do so. In some circumstances, a head teacher may make a decision on the evidence available to them on the balance of probabilities as to what happened and impose a penalty accordingly. Whether or not it is appropriate to investigate and impose a sanction pending the resolution of parallel proceedings will depend upon the circumstances and must be considered on a case-by-case basis by a head teacher. There is no one rule that fits all situations. In some cases, there may be a risk that action taken by the head teacher would prejudice the police investigation and/or any subsequent prosecutions. Alternatively, there may be circumstances which would render it unreasonable for a head teacher to make a decision about what happened whilst an independent investigation covering the same circumstances is ongoing. Careful liaison with the police and/or local children's social services would assist a head teacher in whether or not action is appropriate or whether they should wait. When making a decision, a head teacher should consider a pupil's special educational needs and any disability. The decision to exclude must be non-discriminatory. It must also be reasonable, lawful, and the procedure undertaken to reach the conclusion must be fair. The relevant factors to be taken into account in deciding whether or not to exclude will always depend upon the facts of the case at hand. It is not possible to produce an exhaustive list of factors that will always be relevant or factors that must never be taken into account. Annex B to the Department of Education statutory guidance, whilst not itself part of the statutory guidance, provides a list of useful considerations for head teachers and principals in deciding whether or not to exclude and the right processes to follow. This is also useful for parents as a broad guide to how the decision should be approached. Head teachers should bear that in mind. Some of the factors that I think you should consider when making any decision relating to exclusion are: has a thorough, fair investigation been undertaken? Is the decision being made on the basis of the evidence gathered, or is it being made in the heat of the moment before proper considerations have been explored? Have all applicable policies been reviewed, and has the evidence obtained via investigation been considered in light of those policies? Have the pupil's evidence and views been obtained, recorded and properly considered as part of the case? Have all potential mitigating circumstances and partial defence, such as provocation or history of bullying, been considered? Does the pupil have an EHCP? Should an emergency annual review be called? If the pupil has been persistently disruptive, have staff behaved in accordance with the behaviour policy? Are there any obvious underlying causes? Are there any specific triggers to behaviour? What early interventions have been put in place? Has the school previously discussed the pupil's behavioural issues with parents? Since an exclusion can only be for a fixed period or permanent, an exclusion cannot be for an indefinite period. They must be for a fixed number of days. Exclusions cannot be given for an unspecified or indefinite period, for example, until a meeting can be arranged. Any exclusion of a pupil, even for short periods of time, must be formally recorded. As before, informal or unofficial exclusions, such as sending pupils home to cool off, are unlawful, even if the pupil's parents or carers have agreed to this approach. A pupil may be excluded for one or more fixed periods, up to a total of 45 days excluded from school. This is the case whether the pupil receives 45 separate one-day fixed period exclusions or one 45-day fixed period exclusion. This total applies across schools. A fixed period exclusion does not have to be for a continuous period. Furthermore, a school can exclude a pupil for parts of the school day rather than a full day. For example, a lunchtime exclusion, which counts as half of a school day. So far as the duration of a fixed period exclusion is concerned, it was held in a case from 2004 that a 16-day fixed period exclusion was not a disproportionate or excessive penalty for a pupil who had indecently exposed himself, bringing his school into disrepute, and who had received numerous exclusions previously. The DfE guidance then in force suggested that an exclusion of 1 to 3 days was long enough to secure the benefits of exclusion without adverse educational consequences. This was found in this case to be wholly inadequate given the nature and seriousness of the pupil's misconduct. The DfE guidance was subsequently updated and no longer recommends any period of exclusion. However, it does indicate that where a pupil has received multiple exclusions or is approaching the 45-day limit referred to, the head teacher should consider whether exclusion is proving an effective sanction. In terms of giving notice of exclusion to interested parties, the head teacher must inform the governing body of a fixed period exclusion without delay, where the pupil will be excluded for a total of more than 5 days in any term, or where the pupil will lose an opportunity to take part in a public examination or national curriculum test. A head teacher must also take reasonable steps without delay to notify the parents of a pupil. The notice must contain the following information: 1. The period of the exclusion and whether or not it is permanent. 2. The reason for the exclusion. 3. The parent's right to make representations about the exclusion to the governing body, how representation should be made, how the pupil may be involved in this, and arrangements around any meeting with the governing body when it is legally required to consider the exclusion. 4. If the pupil is of compulsory school age, the notice should warn parents they are under a duty not to allow their child to attend school or to be present in a public place at any time during school hours, and state the days upon which they must ensure this. And 5. If alternative provision is being provided, the start date, start and finish times, address and to whom the pupil should report on the first day should also be provided. Fixed period exclusions must be formally recorded. The law requires all schools, including independent schools, to have an admission register and, with the exception of schools where all pupils are boarders, an attendance register. All pupils, regardless of their age, must be placed on both registers. For school exclusions, schools must use code E. In many cases of permanent exclusion and fixed period exclusions, there is a prior history of persistent disruptive behaviour. In such cases, the DfE strongly advises schools to bear in mind the importance of looking behind the behaviour exhibited by the pupil to see whether they might have unmet needs. Schools are expected to have a strategy for reintegrating a pupil who returns to school following a fixed period exclusion and for managing their future behaviour. Schools should organise a reintegration meeting to help a pupil return to the school environment. This should be seen by both the parents and/or the pupil and the school as an opportunity to devise strategies for future behaviour management, and where the pupil's needs so indicate, the involvement of appropriate professionals and outside agencies. Finally, I want to address the circumstances where a pupil may have returned to school before the governing body's meeting, considering the exclusion. In such circumstances, the governing body must still consider whether the pupil should be officially reinstated, and must not be tempted to rubber stamp the head teacher's decision because they are of the view that it would make no practical difference to reinstate. The decision is not academic simply because the fixed period exclusion has ended. The parents are likely to be concerned about the possible impact upon their child's record of a fixed term exclusion in terms of their future academic career and the schools available to their child in the event that they decide to move their child to a different school. The governors must make their decision on the merits of the decision to impose a fixed period exclusion without regard to that fact. Where a pupil is on a fixed period exclusion of more than 5 school days, the governing body or local authority in relation to a pupil excluded from a pupil referral unit must arrange suitable full-time education for any pupil of compulsory school age. This provision must begin no later than the 6th school day of the exclusion. Where a pupil receives a fixed period exclusion of less than 5 school days, statutory guidance states, whilst the statutory duty on governing boards or local authorities is to provide full-time education from the 6th day of an exclusion, there is an obvious benefit in starting the provision as soon as possible. Where it is not possible or not appropriate to arrange alternative provision during the first 5 school days of an exclusion, the school should take reasonable steps to set and mark work for the pupil. Work that is provided should be accessible and achievable by the pupil outside school. Where a pupil is permanently excluded, the local authority must arrange suitable full-time education for the pupil to begin no later than the 6th school day of the exclusion. This will be the pupil's home authority in cases where the school is maintained by or located within a different local authority. For a pupil with an EHCP, a permanent exclusion necessarily means that the EHCP must be amended because the pupil can no longer attend the named school. As before, a head teacher must inform parents without delay of any exclusion, the reasons for it, and their rights and obligations in relation to it. In cases where a new fixed period or permanent exclusion has been issued immediately after an earlier fixed exclusion, a head teacher must write again to the parents, explaining the reasons for the change and providing any additional information required. Again, a head teacher must, without delay, notify the governing body and the local authority of 1. A permanent exclusion, 2. Exclusions which would result in a pupil being excluded for more than 5 school days, and 3. Exclusions which would result in a pupil missing a public examination or a national curriculum test. For all other exclusions, a head teacher must notify the governing body and the local authority once a term. Where required to consider an exclusion, a governing body must notify parents, the head teacher, and the local authority of their decision and the reasons for their decision in writing and without delay. Where a pupil resides in a different local authority from the one that maintains the school, if that is the case, the governing body must also notify the pupil's home authority. In the case of a permanent exclusion, paragraph 76 of the statutory guidance contains further specific requirements as to what has to be notified to parents, including their right to ask for the decision of the governing body to be reviewed by an independent review panel. Whilst I do not intend to go into this in any particular detail, and whilst the law relating to exclusion relates to all pupils, whether they have special educational needs or not, it is important to highlight that there are some paragraphs in the statutory guidance which specifically deal with pupils with special educational needs. I've highlighted some of the paragraphs on the slide that you can now see on the screen. Whether or not a school recognises that a pupil has special educational needs, all parents have the right to request the presence of a special educational needs expert at an independent review panel. The special educational needs expert's role is to provide impartial advice to the panel about how special educational needs could be relevant to the particular exclusion. Thank you very much for listening. I do have some concluding remarks, which I will move on to in a moment. But before I do so, I'd just like to point out that we have a survey which I'd be very grateful if you could fill out, and the link is available on the slide here. We'd really appreciate if you could complete it so that we can make any of our future webinars helpful to you. We will be sending a recording of this webinar around to everyone that signed up to today's webinar, and you should expect that tomorrow morning. As I said at the start, this is one in a series of Wednesday webinars. Our next webinar is the impact of COVID-19 on contracts. Is the pandemic a force majeure event? If you are interested in our future webinars, please visit our website or our Eventbrite page to sign up. To conclude, the circumstances surrounding any exclusion are likely to be unique in some form or the other. What is important, no matter the circumstances, is that the legal requirements, whether set out in an Act of Parliament or statutory guidance, are followed. It is also important to consider whether there are any particular circumstances where you need to take into account different areas of law that have not been covered today. For example, a student may have protected characteristics under the Equality Act 2010, and you may need to consider whether any actions taken during the process of coming to the conclusion that a pupil should be excluded could be perceived as discriminatory, even if there is no intent of discrimination. In any event, no matter the circumstances, I would highly recommend that you seek the advice of your legal advisor before making the decision to exclude a pupil. A legal advisor will be able to run through the requirements of a lawful exclusion with you in order to confirm that you have indeed ticked all the required boxes. Head teachers need to keep in the back of their mind that their decisions can be reviewed by an independent review panel, and also in the cases of schools that are deemed public bodies, that in some cases their decisions can be scrutinised by way of judicial review. Therefore, it is vitally important that you get it right. My apologies that I am unable to attend the webinar in person today. However, I would welcome any questions that you have. If you would like to discuss any aspects of the webinar or indeed ask any questions, please contact me using my email address, which you can see on screen. Alternatively, call 01245 453 847. I hope today's webinar has been useful.